Thank you.
May it please you, Millie. We had gotten to the point of looking at the consideration of the recommendations for promotion. Just to continue, so we have, having advised the PSC of the vacancy, the Commission met to consider the promotion and ask in particular for the fatal incident report. And we see that is exhibited at pages 138 to 133 to 134.
Yes.
Letter of December 20 from Commissioner Ellington to the Chair, reproduced in the supplemental bundle at page 553. Let's bring that to your attention. Then we go to December 23, 2010, when the PSC met again to continue deliberation and to consider the fatal incident report. See at page 78 of the record from the affidavit of Chairman Shirley. That at the meeting of the Commission, starting at paragraph 29, of 23rd December, which was called to continue discussions relating to officers who had been recommended for promotion. The Commission had before it the fatal incident reports in respect of superintendents and deputies, including Hewitt, which was requested. The returns were submitted on the cover letter 20th December, and the correspondence made reference to a meeting of the Commission on 14th November. That he corrected that the meeting was actually 14th November. And then we go to, we see that the decision in respect of Hewitt was deferred. More information was requested.
Where do we see that report? Page?
At page 78, my Lord.
I see the reference to the report.
Paragraph 30. The content of the reports against all the officers were discussed extensively.
Yes, it refers to GS 15.
At 133.
133. Thanks very much.
So we see that the Commission agreed to recommend 14 of the 21 officers to the rank of Senior Superintendent. Also decided that as regards 7 other superintendents being considered for promotion, including Hewitt, additional information was required, including information on the exact nature of the cases, whether the officers were personally involved in the killing, or the nature of the officer's role. Commissioner of Police was also asked to provide any other pertinent information available from the BSI which could assist the Commission in its deliberations. The Commission decided that the 7 officers would be interviewed individually by the Commission on the 11th.
The list that you showed us in 553
Yes.
Looks as if it's got timings for potential interviews marked in handwriting, do you think?
Preview, ladies. At
553,
at the supplementary.
which is this is the report of December the 20th, 2010, but it's annotated.
Yes.
And against 3 of the names, it says a half, and against Mr. Hewitt's name, it says an hour.
Well,
I'm just wondering whether that was somebody in the commission saying, well, we'll give the others half an hour's interview, but we'll grill Mr. Hewitt for a whole hour.
well, the records show, milady, that so seriously were the complaints considered that the commission took the time to probe as deep as it could, as far as it could, given the mechanism that existed at the time. And in addition to that, they needed to hear from SSP Hewitt himself and to confront him with the allegations. We get the impression from the record that SSP Hewitt may have been targeted by his detractors. You would see from the tone, from what was said by SSP Gauze when he did his first investigation and went to the scene at 100, when he says the detractors involved in criminality have an interest to serve in having him transferred away. But the commission was concerned that the allegations were serious, notwithstanding any explanation that might be given, and so needed to be probed. And among the different things they would take into consideration, the report of the BSI, what the DPP had to say, what returns came from the coroner's court, all things outstanding was to hear from him too. And bearing in mind that the files submitted would have statements from the complainants who would have been interviewed. And the interview of Mr. Hewitt, so
144.
but at the meeting, the PSC decided to recommend 4, and they deferred Hewitt. And we see at paragraph 30, at page 78 to 79, what was to be done. And then we see the chairman saying that, so when they decided to defer, in order to get additional information, they wanted, among other things, also the proposed deployment of Mr. Hewitt. Because bearing in mind, the recommendation for promotion was being considered in a context where a new commissioner came on the scene, is doing his own assessment as to the strengths and weaknesses of the force that he has inherited. He has operational responsibility for the force. All sorts of things are happening in different policing areas, and he had to make best use of available resources. And we put that against what is provided for in the regulations, the police service regulations 15, which says from time to time as vacancies occur, the commission shall consider the eligibility of all members for promotion, and in respect of every member shall take into account not only his seniority, experience, and educational qualifications, but also his merit, ability, and good conduct. So we take no issue with the appellant in saying that in considering the promotion, conduct is something that has to be taken into account. In fact, the PSC is mandated to do so. And the regulation also speaks to Regulation 15.2 in the performance of its functions under paragraph 1, that of considering eligibility for promotion. The commission shall, now this is where a duty is imposed on the commission, take into account as respects each member. It lists there fitness, seniority, education, course of training, markings. And interestingly, in respect of course of training for Mr. Hewitt, we see the special course of training that he had undergone during his time in the force. set out on his personal sheet, pray your indulgence, at page 111. Right, at 111. From 110, 11, 12, we see assessment of the material that would be put before the Commission for consideration. Interestingly, I note that Mr. Hewitt had only been qualified at the secondary level, and when he was assessed, one of the assessors who was a lecturer at the university had suggested that he should be encouraged to go to the tertiary level. We also see, my lady, my lords, that his date of birth is 53. Earlier it was said by my learned friend that he resigned. That is not correct. He actually retired by virtue of age. I don't know. That was no dispute, development since the case. So 60.
Could he have continued beyond the date that he retired?
60 is the top end.
So he couldn't.
Then I don't think, I don't now recall whether there are provisions for that. But they're going through a whole process of assessing the force and, making improvements, vacancies, promoting younger persons. So and that is why December 1 is relevant, because he's born December 2, 1953. So 2013, he would have been at his retirement age. That's when he came out. But to go back to what we have, so he's interviewed, and a number of things are taken into account. The record of the interview, we direct you to pages 144 following. And it sets out a number of things there. His background, his experience in crime fighting in the areas, and in fact, and he stated how many operations he had been in, what the areas looked like that he had been placed in, some of the toughest areas. He said he had spent 9.5 years in Kingston Western and St. Andrews South, the two toughest divisions, one described as a murder capital. And we also see that the appellant had begun complaining round about that time, or the complaints that they received began round about that time when he went into those two areas.
Forgive me, I didn't make a note of the page reference to the interview.
The interview starts at 144.
144, thank
Yes,
you.
yes. Headed interview with Superintendent Hewitt at a specially convened meeting of the PSC held on Tuesday, 11th of January 2010. Mm-hmm. He also said that in the divisions in West Kingston, between 04 and 07, there were approximately 400 persons killed per year. And he had managed to bring that figure down, the murder rate down. Little wonder it was regarded as a murder capital. And then he said in 2009, 241 persons killed in the St. Andrews South Division, and he managed to stop that at 154 in 2010. And he noted that he had expected a 10% reduction, but actually achieved 36%. These are people who are dying at the hands of the criminal element. And he was asked about his view on why he was chosen for the toughest roles, and he said he didn't know, but he assumed it was because of his operational experience. He didn't know, but tough crime, criminals. And then he spoke about the gangs that were active in the area, and he gives the description: over 30 active gangs, still one of the biggest problems facing us in the jurisdiction. And he said he had to face the gangs head on. And interestingly, in some of the operations, he said it involved the military, the flying squad, and mobile reserve. So you see that they were not ordinary police operations that were taking place. And the leadership of the force had to look carefully at how it would respond to what was happening in these communities. People's lives are being lost at the hands of the criminals. And if we go over to the next page, where he said that in the course of his career, he had used deadly force only 3 times. And he conducted many operations and pointed in 2010 alone when he conducted over 11,000 in the division in which he was. Not ordinary activities. I mean, you can only imagine the level of criminality that was taking place. Just the sheer number of people who were being murdered. The high number of gangs. And the brazenness of confronting the police. Again, not a license to kill, not a license for the police to be judge, jury, and executioner, not at all. But if they are
Madam Attorney, I'm just wondering what precise relevance all of this has to the issue in this case. I mean, I think you may take it that quite apart from the experience of this case, the board is very well aware of the many challenges that face society and the police force in Jamaica. That's, I think, been very clearly outlined by you. But you've repeatedly said that this doesn't derogate from the obligation to investigate. So I'm not sure that the rehearsal, or the repeated rehearsal, if I put it that way, of the difficulties that the police force had to confront is going to assist us in deciding whether or not there was in fact a discharge of the statutory obligations of the Commission.
My Lord, I'm guided, and not repeating for the sake, but we're looking at the decision of the PSC to advise the Governor General on the promotion of SP Hewitt in a context where numerous complaints are made against him, and what the PSC had to consider in making a judgment. It's essentially a judgment call. They are obliged to consider promotions as they arise and the filling of the promotions. And it's really in that context in which the decision was made and what they were balancing. So here you have an experienced officer. He's policing in a particular way in particular communities. The force, leadership is changed in the police force. New commissioner is making assessment. The commissioner, has gone through the internal process in the JCF for promotion and is then presenting the results of that process to the commission, who must to do its deliberation, discharge its duties, exercise its discretion under the regs in order to advise the Governor General. It is really the context. But I am guided by your Lordship that the context insofar as what the SP might have faced is understood and put there. But the impression was given that the Commission received these complaints and really had shown scant regard. Because when the question was asked, what is the appellant seeking to get from this hearing? My learned friend had said to set aside the judgment because the Court of Appeal had concluded that the PSC had no role in assessing the complaints in these matters, and the assessment was being done in a particular context. Have the complaints, we have a recommendation for promotion. How are we going to balance taking all things into account? But what we know at the end of the day, before the final decision was taken to recommend SP Hewitt, is that all the files were complete. That is what the DPP says. So having interviewed him, and then you look at the process that they had gone through, the ethics committee that was set up, the lie detector tests that were taken, and all of what is set out in the record, and the PSC meeting to consider, it has to consider the eligibility for promotion in accordance with Regulations 15 and discharge that duty in respect of SP Hewitt. It didn't go ahead. It considered and it reconsidered and it requested further information. And perhaps at this time, I could direct your lordship to the judgment of the Court of Appeal, because the court was grappling with the issue. At page 516 of the record, starting at paragraph 126. But it is still necessary to consider, as JFJ also invites us to do, whether the judge's conclusion that the PSC's decision was not Wensbury unreasonable, whether that decision can be supported. For this purpose, I cannot avoid rehearsing briefly the events leading up to the decision. After discussing in details the Commissioner's recommendations for promotion at its meeting of December 14, the PSC's first step was to request a fatal incident report from the BSI on each of the officers recommended for promotion.
Well, you've shown us that, and of course we have all read the judgment,
Indeed,
so
milady.
there's no need for you to read it out to us. Yes.
Indeed, milady. The tallying was done there, but just to take you to the fact that by the time the final decision was to be made, the DPP had reported that all the outstanding matters had been ruled on. And we see that in her letter.
Page 157 again.
Yes, milady.
It's April 2011.
Yes, milady.
On that, there are 4 matters relating to Superintendent Hewitt which are completed, and one where directions have been given for further investigations. That's a tiny fraction of the matters that were outstanding earlier on.
Those were the matters that were referred to the DPP in respect of Hewitt. Different things happened with the matters, and among those referred to her, those were all that were referred to the DPP, because remember at one stage the rulings were outstanding from the DPP.
Yep.
So now the Commission is taking the step to ascertain what is the outcome of the ruling.
Yes, one of which
Excuse
remains
me.
outstanding.
Milady, in that.
157, 4 up from the bottom.
Ruling completed, no ruling complete.
Directions given.
Directions given to Assistant Commissioner Gores for further investigations to be instituted in relation to the conduct of a named constable
Right.
for possible action to be
Right,
taken.
not Hewitt
But not
himself.
Hewitt, yeah.
Hewitt himself, milady. Thank you for the assistance. All the matters in respect of Mr. Hewitt who was being considered, those matters were dealt with. So an incident may implicate more than one officer. So that was it. And then, milady, just to say that, in Cooper, which is, we just want to refer to, in volume 3 of the bundle. Just going back to what the Court of Appeal grappled with in making its decision.
You give me a page number.
My lord, 1823, it starts at 1813. my learned friend referred to the constitutional framework for commissions like the Police Service Commission. And they're vested with autonomy. So the goal of the framers of the Constitution was to insulate the commissions. And to achieve that goal, they were given autonomy and independence from other bodies. As such, it is for the PSC to exercise its own initiative in the performance of its functions, free from influence or interference. And this is not a case where there was political interference, but I think point we want to make in terms of what there were duties and there were discretions. And in Cooper, the board recognized that and pointed out, we find that at 1823, that a distinction can be drawn between acts that dictate to the Commission what they can and cannot do, and the provision of a facility that the commissions are free to use or not to use as they think fit.
If we imagine the situation where the Commission is considering whether to promote someone, and a number of allegations have been made against that individual of serious misconduct, and the Commission looks at the material that's available to it and decides that it is insufficient to allow them to make an informed judgment as to the validity of the allegations that have been made, what was the Commission's duty, or what would the Commission's duty be in those circumstances?
If it didn't have sufficient information at the time, then it would have to seek to get more information.
Okay.
And there is no dispute about that.
Thank you.
Right. But the Commission concluded that based on all the steps that it had taken, by the time it came to make the final decision in respect of SP Hewitt, it had by that time enough information to make a decision on him. I can understand that all of that was not communicated to the appellants, and it's not unnatural that they would be wondering what is going on. I mean, I think it's most unfortunate that there was a lack of communication between the PSC and the appellant to say steps are being taken, investigations have been done, we're considering on a case-by-case basis. Because you see from the communication that the appellant continues to wonder, are you taking the matter seriously? What is the extent of the investigation? Because they had not been provided with the details of what was happening. And in the earlier time, when they were communicated with, there was no detail. Merely a reference, the matter has been referred to. The commissioner has given an undertaking to have it investigated, but they would not have known. And so, understandably, they would be concerned. And my lord, lady, the appellant has played a significant role in ensuring that positive changes have been made on the Jamaican landscape in dealing with complaints against the security forces, and they have to be commended for that. And we see the development with the Indicom coming in, and now we have the MOCA, we also have the Integrity Commission, and internal reviews within the force, and all the improvements that have been made. Are we where we need to be? Work in progress, but significant improvements. And if the PSC were faced with the same situation now, there is no doubt that in the exercise of its discretion, it would have resort to Indicom. But no.
When you say in the exercise of its discretion, it would have resort to Indicom, first of all, Indicom would have to,
Indeed,
as a matter of statutory obligation, investigate these. At the time that the Commission was taking a decision about the promotion of Superintendent Hewitt, Indicom was in existence. The Commission must be presumed to have been aware of its existence and its remit. Why did it not refer to Indicom the allegations that had been made against Superintendent Hewitt?
The evidence does not provide an answer. The records do not, and it would make sense.
Well, not only would it make sense, arguably,
But it would
was its legal obligation to do that. I mean, if it knows that there is a source of independent verification or allaying of the allegations, the concerns about the allegations, in what circumstances would it be legally open to the Commission not to avail of that source?
My Lord, here is how I would answer. It would be a material consideration for the PSC. If you look at how the case was argued and how the regulations are framed in terms of what is its duty and what is its discretion, it went in a certain line. And I think that is why the Court of Appeal grappled with its decision the way it did. But there can be no doubt that it would be a material consideration for the exercise of their discretion, that here you have a body that has been set up to independently investigate, that it should be referred to. So, and once you call for reports, you must consider the reports. We're happy to say, or at least relieved to say that no, all of this is somewhat academic because the Indicom does its report, the reports are sent to the PSC, and I know my learned friend indicated in the commission, the reports that he put up, the quarterly Indicom report about the concerns. Just to say that what is clear is that Indicom reports, investigates, and if you look at what is contained in the second quarterly report, you see the outcome of the recommendations. And in all of the cases reported there, save I think for one, there was no recommendation for any criminal charge or disciplinary action to be taken. You see reference to a special coroner. And just to say that as part of the improvements that have been made, in 2009, the Coroner's Act was amended to create the Office of Special Coroner pursuant to Section 5A. And the Special Coroner would exercise jurisdiction and functions of the coroner in respect of any death occurring at any place in Jamaica where there is reasonable cause to suspect that the death occurred as a result of the act or omission of any agent of the state. Why that was necessary is that the resident magistrate, now parish court judge, was also the coroner, and the jurisdiction was parochial. The concern among the concerns was that matters that were referred to the coroner involving state agents got lost in the queue of the other many matters that were being dealt with in the coroner's court. And so as part of addressing specifically the issue of delay in the system, where matters had to go to the coroner as a matter of course, this Office of Special Coroner was created to deal with those matters relating to the agents of the state. And a reference to the coroner is usually done where there is no indication that anyone is criminally responsible. But you still have to complete the process because there is a death. So you would see the DPP would make a ruling. If there is someone to be charged, that person would be charged. If there is no charge but disciplinary action is to be taken, that recommendation would be made. If neither criminal charge nor disciplinary action is recommended, then as a matter of course, in order to complete the process of dealing with the death, it would go to the coroner. And that would close out the matter, because that is what the system provides for all deaths in circumstances where it's not clear or where there is no reason to suspect that a crime was committed, then the coroner rules off and the case is closed on it. So even in the JFJ's, the INDICOM's report, and the INDICOM reports promptly, and it's well publicized as part of the public confidence building. You see the number of cases, and the number of cases is an indication of the kind of confrontation that takes place between state agents and the public who would operate contrary to the law. And you see the listing. Having investigated independently of the police, no criminal charges or disciplinary action. No criminal charge, and it's all the way down. And in one case, we see where a report would be appreciated, the Police Service Commission and the Solicitor General were advised accordingly. On page 17 of the second quarterly, April to June 2018. So imagine all these matters where you would have, just by sheer number of deaths, persons shot and killed, and we don't have the benefit of the INDICOM, naturally it's going to cause concern. Or if you juxtapose it against the police internally investigating through the BSI or otherwise, and ruling that the use of force was justified in the circumstances. Now that we have the INDICOM, the same ruling, then there is no suspicion because it's independent. But it just reflects, unfortunately, the high level of confrontation in the criminal element and the police force. But that as it may. So, just to get to it, my lord, my lady, we take some comfort in the fact that what now exists is different. Vastly improved. And there can be no doubt that in the exercise of its discretion, and we say discretion because on any interpretation of the regs, that is what is provided for. The PSC would call for reports from the INDICOM, and we're happy that it would not even have to call for it because the INDICOM sends it and it considers it. Because once it gets the report, it must consider it. It has a discretion whether to get it, but having received it, it has a duty to consider it.
And in fact, as you say, INDICOM investigates all state agent killings and has to send its report to the Commission. So the Commission is bound to get it whether it wants it or not, whether it asks for it or not. And having got it, if it's relevant to any question before the Commission, you'd accept that it has to consider it. Mm.
So we say, my lady, that there is much good in all of this. Don't believe that when you look at how the case was argued and what the Court of Appeal grappled with against the evidence, that the court should be faulted for.
That's in effect what you have to say, isn't it, Madam Attorney?
Unless I can be of any further assistance.
Well, thank you very much
So
indeed.
please you.
Thank you. Ms Jarrett?
My lady, can I take advantage of the special privilege I was granted?
You may. I never mind if people address us sitting down. I think it's counsel who usually prefer to be on their feet so they can harangue us.
Well, I'm not sure so I can harangue, but I do find it easier normally. But I think on this occasion I'm going to change my normal practice. Can I deal with three outstanding things, I think, raised by members of the court this morning? Firstly, a very simple one, the letter where the Commission had said it was fully informed. It was page 53. I think I added in my notes an extra page number, but it was page 53, and it's the 29th of March letter. I think that was Lord Kerr asked that. More significantly, perhaps, Lord Briggs asked me about the meaning of charge. It's paragraph 27A, which is bundled page 586 of our statement of case, cites De Vere, which is at volume 3, tab 24.
I'm sorry, paragraph?
Paragraph 46 of the judgment.
No.
Oh, sorry, paragraph 27A of our statement of case.
Yeah.
And also makes it clear that, unsurprisingly, the European Court is unwilling to accept that states can effectively avoid their obligations by doing nothing. It indicates that effectively the state can still be liable where it ought to have acted, basically. De Vere is the authority for charge, and Janowick is the authority for the obligation where a state ought to have acted. Thirdly, Lady Black asked my learned friend about the number of cases outstanding when the decision was taken. We've been through over lunch, and it slightly depends on how you calculate this. Page 188 is a summary of the memories in the record of proceedings, is essentially a summary of the response to the complaints that had been made, and it identifies 28 complaints in the first sheet, the first sort of table. On our calculations, of the 28 complaints, 11 were still sort of in the investigative stage. They hadn't been referred to the DPP or anybody else. If one looks at the most recent fatal shooting report, which is at page 152, that is essentially compiled in a different way because it's effectively a list of shootings or killings rather that SP Hewitt was involved in one way or another. That starts, as I say, at page 148. Sorry, it ends at page 152 for some reason. Starts at 148. That lists 36 shootings, or killings rather, of which by our calculation 14 were listed as incomplete investigation. I may have done the maths wrong, but that seems to be right. That's excluding cases which had gone to the DPP, where there had been, for example, no final decision.
Sorry, that's excluding cases.
Excluding cases. A lot of those were cases where what seemed to be awaiting was ballistic reports, for example.
Thank you. The figure of 11 out of 28 coincides with the submission made in the Court of Appeal that there were 11 cases within the remit of Indicom.
Yeah. I don't think that's the same. I think that's a coincidence as far as I can see.
Thank you.
And I should finally say, just in terms of these figures, because there's been reference to page 157, which is the table from the DPP. That table, which is a shorter table than a number of other tables, as I understand it, that's cases where there had been a reference to the DPP, and it was effectively the DPP saying, these are the ones I've dealt with. Cases where the investigation was still pending were not in that table, and that's why it was a short table. Can I then deal with some of the factual submissions? I'm not going to take a huge amount of time, but there are a couple of things a few things I need to respond to. Firstly, my learned friend started by making the point that the appellant's initial letter which is the letter of the 27th of July 2009, did not, or accepted essentially, that there was, that the appellant was not in a position to provide evidence. That's correct.
Just refer us to the letter again, Mr. Southey, please.
I've just realised, I think it's page 28.
Thank you.
It starts page 27, but the relevant passage is page 28. Of course, that's correct. That's what the letter says, but that doesn't detract from the fact that, of course, the obligation, the obligation is imposed by the right to life is an obligation on the state, and for good reason, because the state is in the best position to gather evidence, essentially. My learned friend says what then followed, essentially, was action on the part of the Police Service Commission. Now, of course, the real question in our submission is not, was there some action? Because there was some action. The question is whether there was an effective investigation, whether or not there was a sufficient investigation, in particular, to ensure that the PSC was properly informed. And what one sees, essentially, in our submission is that in terms of the information the PSC had, firstly, it had the letter from the BSI, the letter at page 100, which was the letter of 20th of December 2009, which was accepting that there were questionable shootings and saying these allegations need to be investigated.
Sorry, the letter from the
BSI. It was Assistant Commissioner Gauze.
reference?
Page 100 of the electronic bundle,
Yeah.
where it was accepted that there were some shootings that were questionable and the allegations were serious and needed to be investigated. One then had the various fatal shooting returns that one has seen, the first of which was the one of the 7th of January 2011 at page 140. And what one sees in those is, from the PSC's point of view, as I've already indicated, firstly, a significant number of those investigations were outstanding. Some of them are outstanding for a significant period of time. There was no attempt to summarise the evidence. It's difficult to see how the PSC could have formed any view about how serious the allegations were, or how concerning the evidence was. And they were provided by a body that lacked independence. One needs to remember that by the time one's getting to the decision in question, Indicom was in existence. Now, my learned friend says, don't lose sight of the fact that there were only 2 cases in which the officer in question was the shooter, but that ignores the fact in our submission that as team leader, he would still have been subject to duties under the right to life. We make reference in our case to the fact that, of course, one needs to organise incidents, or one needs to organise rather the use of force in a way that safeguards the right to life.
Do we know anything about Indicom's remit or policy once set up about whether to focus on new complaints coming in or to go back historically and look at old ones? And one can well imagine that could be quite difficult.
Well, it could be. I accept that. But one, we don't know what Indicom was doing. And 2, on the facts at the very least, there were some new complaints because if one looks at the, not a huge number, but if one looks at the, just looking for the reference to it, there is a document where the appellant summarises the complaints it has made. Actually, I can probably find that from my notes. That makes it clear that the appellant had made some complaints to Indicom once it had been set up.
But about events that had occurred after Indicom had set
Absolutely,
up.
yes.
I suppose you might also say that the Commission had the opportunity to refer even historical complaints to Indicom. It wasn't obliged. It may be that Indicom would have said, well, I'm sorry, we're just inundated, we're not going to investigate these. But certainly it was open to the Commission, in the knowledge that Indicom existed, to at least ask them whether they would be prepared to undertake an investigation.
Absolutely. One could imagine a communication which perhaps would have made sense, where PSC had said, look, we have this quite difficult decision to make. We've got an officer where there's a lot of concern. Can you help us? Are you in a position to prioritise this? And Indicom say, no, terribly sorry, we're not in that position. Now, that would perhaps make the case very different, but that's obviously not what happens. There's no attempt to contact Indicom. Sorry, it's page 59. I was looking for in my notes for the reference. Page 59 is where the appellant summarises in 2011, early 2011, the complaints he'd made, and one sees that the last 3 complaints were made, whereas previously the appellant was making complaints to a range of bodies, particularly the Bureau of Special Investigations. The last 3 complaints went to Indicom.
And those related to Mr. Hewitt, did they?
Yes, that's as I understand it. Yes, because that's the context in which that. Yes, if one goes back to page 57, the heading is Superintendent Delroy Hewitt and officers ostensibly under his control.
And do we know what the outcome of the investigation?
No. No, there's nothing in the record that indicates.
So they were actually in the course of investigation by Indicom.
Apparently, yes. And the submission, which is a couple of submissions really legally that are at the heart of my learning friend's case. First is the Commission couldn't embark on an investigation. Well, whatever its resources, it was still subject to, or it was still responsible for discipline. It needed to make sure there was adequate progress with investigations. It was subject to the Charter, and the information it had was simply inadequate in our submission. It had no idea whether or not what concerns had been raised by any investigation. It had no idea why investigations weren't, or limited idea rather, why investigations were not proceeding. There were one or two, well, there were investigations which were said to be stalled by ballistics, but the significance of that wasn't clear. In our submission, quite clearly, both as a matter of domestic public law and because of the Charter, more needed to be done. Now, my learned friend says at the heart of this was a balancing act, but that can't be right in our submission because the right to life is an absolute right. Over lunch, and I can provide hard copies of this, but it'll need to be after the hearing, we located the case of Gulick and Turkey, which is where the European Court dealt with a very similar argument presented by the Turkish government. The Turkish government said, we can't fully investigate what is happening in the Kurdish region because of the number of cases. And the European Court rejected that. It's, the reference I've got is 28 EHRR 121, and it's paragraph 81. We'll supply an 82, and we'll supply a hard copy. And there's a good reason in our submission why resources can't be an answer, and it goes to the point I made in opening, which is made by the Inter-American Commission in Wallace Media, which is if you don't investigate properly these cases, ultimately you undermine, as a state, your own ability to enforce the law, because your actions result in a lack of public confidence. And that's the problem, is if you don't investigate these cases fully, you end up on a downward vicious circle, where things become, where the law becomes more and more difficult to enforce. And my learned friend says account was taken of the complaints, but of course, the problem is there wasn't the material before the Commission to allow it to assess the significance of these. What one sees in the end is that everyone was promoted in circumstances where the Commission had no way of knowing how serious these complaints were. And the interview didn't really assist in our submission, not least because of the point I made in opening. If one looks at the marking scheme, page 126, there was no attempt in the interview to assess the allegations and whether or not they were credible allegations through the interview. Reference, I think, was also made to lie detector. We can't find any reference to that being used in relation to SP Hewitt. Malone and Friends' other sort of fundamental point is that the Commission is intended to be insulated, so it's free to exercise its powers as it sees fit. But of course, it is expressly bound by the Constitution, and the Constitution includes the Charter, so it has to comply with the right to life. It also has to ensure it has sufficient information because it's required to take objective decisions.
Does your case depend upon the proposition that the Commission should have found within its resources the opportunity to conduct an investigation? Or do you say, well, the Commission should have recognised the deficiencies in the information that it had and at least registered those and made representations to the government or to the governor or whatever?
It should have done two things at the very least. Now, whether it should have done more may depend on the outcome of those two things, but it should have done two things. Firstly, it should have sought more information, essentially, from the police about this, what their investigations had shown, and what the state of their investigations were, and why so many were delayed. Secondly, given that Indicom was in operation, it should have approached Indicom to find out whether it was conducting investigations, what stages they'd reached, and whether Indicom were likely to be able to provide information within a sensible period of time. And I should say in relation to that, I mean, Malone and Friends accepted, I think a moment ago, correctly, because it's quite clear from the statute, that Indicom is obliged to provide material to the PSC. But we would say you can't wait in these circumstances because, of course, there's a spectrum. At one end, the Indicom may not have provided information, but may be in a position to say, well, we've almost completed our investigation and it's pretty clear that there are serious concerns about this officer. At the other end of the spectrum, obviously Indicom may come back and say, well, we've almost completed our investigations and there's nothing to worry about here.
I think what the Attorney General says is that you've nailed your colours to the mast of requiring the Commission to conduct investigations, and that there was no statutory obligation, no practical opportunity for them to conduct investigations.
Well,
and that's the reason that your case failed before the courts below.
Well, I think it's fair to say that there was argument that the PSC should have conducted its own investigation, but it's quite clear as well, as Lady Black pointed out, that it was also being said Indicom was the way in which that should have been carried out.
And do you say that all of the outstanding cases should have been addressed by Indicom?
Well, we don't say all the outstanding cases should have been I've got no reason to go behind the comments that were made in the Court of Appeal about how many potentially came within Indicom's, but at the very least one needed to find out what Indicom was in a position to say before taking any decision.
Thank you.
I think that probably concludes.
Covers everything.
That covers everything.
Yes.
Thank you.
Very well. Well, thank you to all of you, not only those who've been on their feet, but those who've sat behind and beside you, who've no doubt contributed to the preparation of the materials before us. We will now take time to consider what advice we will humbly offer to Her Majesty. And we'll now adjourn.